There is still outrage over a constitutional court order to release Chris Hani's killer Janusz Walus. He is responsible for the very famous 1993 assassination of the SACP leader. The party is now calling on the Correctional Services Minister to defy the Concord judgment.
Well, it's also heading to the African Court on Human Rights. So let's get some legal perspective now on the issue with the expert, Kathleen Powell. Kathleen, thank you so much for your time this morning. Let's talk about it. I mean, we've got the understanding that the apex court is the highest form of, legal kind of recourse or legal decision-making in South Africa. But now we see that the African Court on Human Rights is actually being approached for this very same matter. Where does that sit when it comes to the legal framework and perhaps even the influence and possible extension of justice that could be offered by the African Court on Human Rights?
The African Court on Human Rights would hear a complaint by the Hani family, I imagine, against South Africa for releasing Janusz Walus. I struggle to find on what ground it could hold for the Hani family. But if it did, if it held that South Africa has infringed on the rights of the Hani family by releasing Janusz Walus, it could order South Africa to redress that measure. I don't know what form the order would take. It's possible that it could order South Africa to re-arrest and re-imprison Janusz Walus. If South Africa does not do that, the African Court of Human Rights can't send police in to arrest everybody. What would happen is that South Africa would be in default or in a breach of its obligation against the African Court, and it would be a matter that would be dealt with at the African level. But I do need to say that I don't think the chances of an appeal to the African Court are very good. For one thing, South Africa has not accepted the jurisdiction of the African Court for complaints from individuals to be brought directly to the African Court. So it's first going to go through the African Commission. There's a long involved process. So we're looking at a couple of years. And secondly, it's difficult to argue that your rights have been violated because you think that somebody who has injured you has not been punished enough, when the law of the land is applying its punishment rules even-handedly between the person who injured you and everybody else. I think that would be the problem that the Hani family would face at the African Court level.
Kathleen, so many people in South Africa, even at government level, even at political party level, civil society, are saying that Chief Justice Raymond Zondo has essentially betrayed South Africa, betrayed the democratic South Africa, betrayed black people, by allowing Janusz Walus, who Michael Masuta at some point was the Justice and Correctional Services Minister, fought against the release of Janusz Walus on parole. It started when he was in power, actually, and now Ronald Lamola. But the law was followed, no?
Yes. Yes, look, the problem with instances like this, I think, is often that the law is turned to right wrongs that the law was not designed to right. The law is designed to bring justice for the community and the country. It can't bring a sense of closure to each person who has suffered terrible pain. So what Chief Justice Zondo did, and remember that was a unanimous decision, so it's not just him, it was all the judges on the bench, was that they applied the rules in the Correctional Services Act, combined them with the Constitution, and came to, quite frankly, the no-brainer conclusion that Janusz Walus was eligible for parole and should have been released years ago. Of course, that is devastating to the Hani family, but at that point, law can't help them any further. I can think of a number of other things that could make their load less painful now, but law can't do it by singling out special cases, because then we all lose the security of the rule of law.
Yeah, it's quite difficult, especially when it comes to even the way in which the African Court on Human Rights would be able to enforce the law this time around. And as you're speaking about jurisdiction as well as the recognition of South Africa in terms of the jurisdiction of the African Court on Human Rights. But on the other side of it, I mean, for the African Court to overrule, potentially, let's say hypothetically speaking, potentially overrule a decision by the apex court of a country's land, would that not be stepping on the feet of sovereignty of a nation? I'm just trying to look at how would it apply the law? How would the application of law not step into international relations territory where sovereignty is concerned?
Definitely. And that's exactly one of the reasons why the African Court can't enforce its own judgments. So it is a sovereignty problem, but states solve that problem by willingly submitting to the jurisdiction of the court. They sign up. So South Africa has signed up to the jurisdiction of the court. It just hasn't signed up to the extra process whereby individuals can bring claims directly to that court against it. And then when it decides the case, the African Court of Human Rights will use the African Charter, excuse me, to which South Africa is also a party. So the African Court is applying the rules that the state before it has already accepted, and the state has also already accepted the jurisdiction of the court. I'm just not sure where in those rules there is a right to demand more punishment. So that's the warning I'm trying to sound.
It is a warning that I think needs to be heard by many people, Kathleen, but we'll leave it there with you this morning.